Good morning or good afternoon, everyone. My name is Michael Lambert. I'm chair of the Sheehan Finney litigation group, and I'm a member of the firm's management committee. Welcome and thank you for attending today. I'd like to introduce Doug Verge, who has been with the firm for 38 years. Doug is co-chair of our data privacy and security practice group. Doug handles the privacy and security compliance issues. The other chair of the group, JP Harris, who's not presenting today, but he's an important part of the team, deals with data security breaches, document retention issues, and litigation. Doug's presentation today is a high-level overview of the issues and obligations that the comprehensive privacy laws from the U.S., from the states, and from many countries that HR professionals should be aware of. After Doug is done with the presentation, our folks, Liz Tezick and Kelly, will send you an email with a copy of the presentation, the materials, the recording, and the HR credit information. Without further ado, I'd like to introduce Doug Verge. It's all yours, Doug.
Thank you, Mike. Good afternoon, everyone, and thanks for joining. I can only imagine, I understand myself as a data privacy professional, how frustrating and somewhat overwhelming all of these laws can be. So I can only imagine what it must be like for organizations who have to try to figure these things out and wade through them. So what I hope to be able to do today is focus on these new comprehensive privacy laws like the CCPA and the GDPR and what impact they have on organizations from an HR point of view. As Mike said, it's a high-level presentation, but I'm more than happy to answer specific questions if you reach out to me after. So let's jump into this. Hopefully. There we go. So most, if not all, of these general privacy laws, they apply to an organization's collection and use of personal information. And the interesting thing is, HR, we often think just of employees, but it's not just employees. As we're going to discuss later on, the California privacy law applies to job applicants, owners, directors, officers, LLC managers. Technically, that's not identified, but they're so similar to directors and officers, I've included them. Medical staff members and independent contractors. So as an HR person, you deal with these other individuals in different capacities, and you have to keep them in mind when we're talking about these laws. The other thing is that each one of these laws is different in some respects, although they generally cover similar concepts. There are extremely significant penalties and liabilities for non-compliance, especially under the new China's new PIPL general privacy law, under the GDPR, and even laws like the CCPA. They might not be talking in terms of 20 million euros as a potential outside penalty, but there are per violation penalties that can range from $2,500 to $7,500. And it's unclear what a violation is, whether each day you're in non-compliance, that's a new one, or is it just the one time for that particular individual. Anyway, from your point of view, the key point is wherever you have employees or workforce members or these other categories of people I mentioned above, you've got to figure out whether there are privacy laws that might apply to them. So let's talk a little bit what privacy is. In its essence, it's a fundamental human right of individuals to be free from unauthorized intrusion. And that includes the right to restrict access to their personal information. When we talk about personal information, I think some folks think it's just identifiers like your name, address, social security number. And while that's a very important part of it, it's not just that. It's any information that either directly or indirectly can identify a natural person. When I use natural person, I also mean individual, or sometimes what's called a data subject. So it has to be something that can either directly or indirectly identify an individual, or that relates to that identified or identifiable person. So what that means is that once you know who, or can figure out who somebody is, it's not just their name and address, it's things like medical records that relate to that person, education records, employment records, geolocation information. And we're going to talk in a couple of minutes about what all of those things are that could be considered personal information. It's also important to know that in some instances, publicly available personal information may be exempt from coverage under certain privacy laws, but it's not true that any type of publicly available information is not also considered to be personal information. So for example, under the California privacy law, to be exempt, the publicly available information has to come from certain official public records, not something that you pull off the internet about somebody. So I'm not going to get into great detail with these two statutory definitions, but they both are basically the same, and they just reiterate what I just told you. One of the main differences is that California also refers to households. I'm not really sure how you necessarily know how some of this information would relate to a household, but obviously there could be a computer that's shared by a household, and technical identifiers like IP addresses, browser or device identifiers also are considered personal information. So that's an important point to keep in mind. So here are the specific categories of personal information, no particular order, although I will say the order more or less mirrors what the California privacy law indicates. So the first, we talked about identifiers, and I kind of think of identifiers as broken down into different subcomponents. You have what I call common identifiers like names, addresses, phone numbers. Then you have what I call assigned identifiers like social security numbers, driver's license, different account numbers, passwords, that type of thing. And then you have what are called technical identifiers, which could be IP addresses, device identifiers, and then you can have what are known as indirect identifiers. And these are things that could be combined with other information. Like, let's say you know the street, but not necessarily the number, or you know the person's last name, not necessarily the first name. All of those are PI, and I'll use the term PI sometimes as an abbreviation for personal information. Then we have protected class characteristics or sensitive information, which as HR professionals, you most likely deal with on a regular basis. And you know what those are, but it's, race, gender, sexual orientation, religion, even criminal records. Biometric is becoming more and more important. In fact, Illinois and other states have biometric or genetic privacy laws, but there have been a lot of class actions under the Illinois law because it, unlike some of the other laws, allows for a private right of action. And I've seen a lot of cases within the past year. But fingerprints, face prints, DNA, even exercise data, if you maintain that as part of a program for your employees, that's biometric information. The internet information, it's not just the IP addresses and things like that, but it's search and download histories, if you use cookies or other persistent identifiers or browser information. Geolocation, GPS, RFID, if you track or monitor your employees or independent contractors, that is personal information. Even physical and vocal characteristics like images of somebody's face or the sound of their voice, or, crazy under the California law, even the way somebody smells, if they're known for wearing a certain perfume, that could be personal information along with written descriptions. Any professional or employment information, applications, contracts, performance records, citizenship. Education information could be academic performance, special education, health, attendance, activities and awards, all of those types of things. Health information, medical, dental insurance records, and in, covering what you would typically think. Financial information. So if you have any bank, credit card, other account information, loan, mortgages, credit histories, those types of things are PI. Communications information, not necessarily the, business related, communications intended for the business, but sometimes, as we all know, employees use email or search the internet or make social media postings using, company facilities, and you may be looking at, some of their emails and the like, or listening in on conversations, and that would be PI. Commercial information, records of what people have purchased, different things like that, customer records, and then inferences. So if you use any combination of the above things or any of them to profile people to figure out their behaviors or that type of information. So all of that is PI. So now there's this concept called data mapping. And when I'm working with clients for compliance, I always ask them, do you do any data mapping? So what data mapping is, it's basically understanding what personal information you collect, where it comes from, why you collect it, what you do with it, how long you keep it, it's tracked across all of those categories of personal information that you just saw. It usually requires having every department in your organization work, to come up with this information. And it's necessary to comply with your privacy law obligations. And just, to know, if somebody asks for a copy of all their personal information, you need to know what you've got and where it is. And, so that's very important. I have a fairly substantial Excel spreadsheet with some check boxes and things like that I've created to help clients figure this out. So when we talk about these comprehensive laws, I just wanted to point out there are a lot of privacy laws, not just these newer comprehensive. There's federal laws like HIPAA, FERPA, and the like, Gramm-Leach-Bliley, and many of you may be familiar with the PCI credit card standards. COPPA is the Children's Online Privacy Protection Act, which applies if you collect personal information of children under the age of 13. There are state laws. California, Colorado, and Virginia are the 3 states so far that have comprehensive privacy laws. There are specific state laws, employee surveillance. New Hampshire has a video and a wiretap. I don't believe Massachusetts has a video, but they have a wiretap. So obviously, if your video captures audio, it could fall under that. And Massachusetts has a general privacy law that might pick it up as well. And then there are the foreign laws, like the General Data Protection Regulation in the European Economic Area, which includes the European Union. With Brexit, the UK has its own version of the GDPR, which is virtually identical to the European one. Canada has something called PIPEDA, I forget what it stands for, but they also, at least 3 of the provinces, Quebec, I think, Alberta, and one other one, have their own privacy laws. China has a really new law which has some significant penalties, and Brazil has a law that's virtually identical to the GDPR. But I read a study the other day, or some statistics from, I think it was the United Nations, saying that approximately 71% of all countries have some form of privacy law. And unfortunately, the US doesn't have a federal one yet. So we have to deal with all these state laws. There are, here are some concepts that I may be referring to that you should understand. So a data subject is a person about whom the PI relates. A controller is a person that figures out what information is going to be collected and why. A processor is a service provider who processes that information. It could be a credit card processor or analytics like Google Analytics. And process basically means doing anything with personal information, even looking at it, possibly even having access to it. So these comprehensive privacy laws, they have a lot of different requirements to the extent they apply. The main things that they cover are notice requirements that you have to give to individuals, the rights that you have to tell them they have, and we'll talk about those in a minute, They have record-keeping requirements, training requirements, security requirements, and data breach preparation and action requirements. So the two I'm going to use as examples, the CCPA, which was amended by the CPRA in California, recently. And first of all, you have to figure out whether you even fall within any of these laws. So to fall within the CCPA, you have to do business in California. You have to collect all of these states. You have to be collecting resident information. And so in California, it's a $25 million threshold. But even if you don't meet the income threshold, if you basically process 50,000 or more consumer household or devices, alone or in combination PI, you fall within it. And if you're basically in the business of selling PI, and so that 50% threshold is another one. And you're also covered if you're a parent or a subsidiary of an entity that falls within that criteria. So in general, and this is interesting, the CCPA doesn't apply to personal information collected by a business about these categories of people that I mentioned at the outset, including employees and independent contractors, except, but it only does not apply for information collected in their roles in those capacities. But it's really important to remember that if an employee goes on your website and buys a pair of shoes, then all of the other privacy aspects of the CCPA would apply to them. There are some other exceptions too, like emergency contact information for people and to administer benefits for other people too, who are related to the employee. There's also this notion under the CPRA of sensitive information. So these are the three things that under both the CCPA and the CPRA as amended that you as a business have to do. And this directly implicates HR professionals. So you have to tell all of those 6 categories of individuals what PI you collect and why, and whether you share or sell it. And then you have to tell them what sensitive personal information you collect, and if so, why and whether you sell or share it. And you're supposed to tell them the length of time that you intend to hold on to that personal information. And if it's not possible to give a specific time period, like 6 years, which I think might be the time period under HIPAA, then you have to tell them the criteria. So it might be, we hold on to it in accordance with our data retention plan or as otherwise required by law, something along those lines. So I won't spend too much time on sensitive personal information because you can read it on the slide, but it's very similar to the protected class information, but it's all of the types of things that you might expect sensitive information to be. And one thing I wanted to talk about, a special note about Colorado and Virginia, is their comprehensive privacy laws specifically say they don't apply in the employment context or the commercial context. But it's not clear when they say employment, whether they're also referring to owners, directors, independent contractors, the way that California does. But what those laws do say is they only apply to a natural person acting in an individual or household context. So I think there's a good argument to be made, and it may well be the proper interpretation, that any context that's related to the non-commercial or I'm sorry, the non-sale activities of an organization to outsiders probably wouldn't fall under those laws, but it would require specific analysis. The General Data Protection Regulation, to fall under that, you would have to basically have employees or contractors or those other categories of individuals located in the European Union or the European Economic Area. And the law doesn't require that there's a citizen of the EEA. It's anyone located in the EEA. So if you have even one employee or a sales rep potentially that's located in the EEA for more than a temporary period. In other words, they have a home office even there, that could pull you within the GDPR. The other ways you get pulled in, or if you offer goods or services to people located in the EEA, or, and this is one that people often don't think about, if you monitor the behavior of data subjects that are located, the behavior is taking place in the EEA. So if you have employees or other people that you monitor their email correspondence, or you monitor their travels or anything like that, or you apply cookies. So technologically, you're kind of tracking what they're doing. That could pull you within the GDPR. The other one's probably not relevant to most people, but you can read that. Some other important requirements of the GDPRs, and the UK one, as I said, is basically the same. You need to have a legal basis under their law for obtaining the personal information from individuals. So it could be consent, it could be to perform a contract, could be what's called legitimate interest, which means that your need for the information, when balanced against the privacy rights of the individual, outweigh the rights of the individual. It's interesting that I work with a lot of European lawyers, and they've said that consent may not even be valid when you're in the employer-employee context due to the imbalance of power. And it's also unclear whether at-will employment agreements would even satisfy the contract basis. So you're left with the legitimate interest criteria, which I think is likely to apply, because as long as you're collecting the information for benefits or compensation or whatever it happens to be, you have a legitimate interest, which are actually favorable to the individual, not in opposition to the individual's rights. And the other thing is, if you're getting information about individuals in the EEA from other than the individual directly, in other words, you're getting it from another organization, there has to be a separate legal basis to be able to transfer that data outside of the EEA into the US. Now, there was a case I mentioned at the bottom called Schrems. People call it Schrems too, because this fellow Max Schrems, he brought an action that managed to get the High Court in the European Union to strike down the validity of the safe harbor law that was between the EU and the US, and recently managed to have the Privacy Shield struck down. So without those two, what are called adequacy decisions that say, yes, we think the US is a safe place to transfer personal information to from Europe, we're left with these things called standard contractual clauses. But I think you all know that by contract, we can't stop the government from snooping. And that's why that was the whole issue in this case is the US government has a lot of different ways that it can surreptitiously obtain personal information of people from Europe, or can order companies to turn it over. And so that was a big issue. And that's a very sensitive area that requires a lot of analysis if you are receiving, transferring information from the European Union. So you need a data processing agreement under the law to be able to do that. And that's an important thing to keep in mind. Geez, we're running out of time here, but if you don't mind, I'm probably going to spend an extra 5 minutes or so to cover these things. Notice requirements. So these are the different types of notices that the GDPR and many other privacy laws would require you to put into a privacy notice. If you think of the privacy policy you have online, you need something similar to that for your employees and those other persons that we talked about. So it's basically the who, what, where, why, and how. The other thing that your privacy notice has to include is the rights of data subjects. And there are a lot of different rights, but the most common are the right of access, the right to get it in a copy where they can transfer it, to correct things that are wrong, to restrict what you process, to object to it altogether, and to ask to have the info erased. That can be dicey if there's a law like HIPAA that says it can't be erased. So that requires further analysis. You're also, generally not supposed to make automated decisions about people unless at least there's a human who can get involved and help sort things out. So these other things I'm about to talk about, even though they're requirements under the GDPR, they also apply to the state laws and are good privacy practices in general. So you need to document everything under these laws. The data mapping is important. You have to have policies and procedures in place for all of the things that are required to comply. You've got to do the required notices, and you have to do really good record keeping. So all the decisions you make with regard to personal information, what you're collecting, why you're collecting it, the requests you received, did you respond, did you refuse, why, how did you respond, all of that has to be documented. And then you should have a document retention plan. Often though, those plans don't highlight PI in particular, so you need to make sure that those two things are coordinated even if you have separate plans. Security, absolutely critical, regardless of whether these laws apply, but any of these laws are going to mandate that you have appropriate security. And they usually divide it into 3 areas. So there's organizational or administrative, which is risk assessments, policies, plans, procedures, training, limiting access to, of individuals to PI within the company. Then physical, what you'd think, locks, guards, alarm systems, surveillance cameras. And then last, but certainly not least, technical, which are firewalls, anti-malware, penetration testing, all kinds of activity logging and monitoring. And really important, especially under the GDPR in that Schrems case, pseudonymization and encryption. The difference is with the first, you have a way to put the information back together theoretically, but with encryption is it can't be read unless somebody's got a key at each end. And there's encryption in transit, encryption at rest, and then there's also the concept of encryption in use. But I know IBM has a software program that will do that, but it's extremely expensive, and it's probably something the government could afford, but most companies couldn't. Just as a quick aside, Massachusetts has a requirement that you have to have a written information security plan in place if you own or license personal information about a resident of the Commonwealth of Massachusetts. So personal information I've laid out there, but it's first and last name or first initial and last name, and so it's a 2-part criteria: a social security number, or driver's license, or state ID, financial account number, or credit card, or some other number. And this is important. It says with or without any required access code or credentials. So just having somebody's name with an account number would bring you within this mass WISP requirement. And then there's an exception for certain types of public information. I can't emphasize enough how important training is. You need to have somebody who understands the privacy laws and requirements, and you have to have training in place. And that sometimes that's a combination of HR and IT, and there may, if you're a big enough company or you process enough personal information, you might need a data compliance officer. And certainly, lawyers and other professionals can help with that too. But it's important to, understand what notices are required, what the data subject rights are, how you respond to those. You have to understand security. I know at the firm we have routine training on phishing attacks and different things like that. You have to understand and implement all the documentation. You have to understand and implement appropriate risk assessments. That's something that you should do at least annually. And in theory, anytime that you incorporate some kind of new software or some kind of new change that could put PI at risk. And finally, you have to understand and implement appropriate data breach plans. Data breaches and incidents. You have to have a preparedness response plan. You have to be aware of notice and reporting requirements, and there may be other requirements such as remedial assistance that are important if somebody's information is disclosed in an unauthorized fashion. Keep in mind that some of the privacy laws, there may be limits on these rights of individuals. Some are imposed by law, like the criminal laws or evidentiary laws. Some are allowed under the laws, like employee monitoring in certain instances. And even within the laws themselves, there may be exceptions to one or more of the obligations to comply. One of the things is they make excessive requests, or if you can't tell who they are, or it might be a preemptive law like HIPAA or FERPA that limits it. So we're almost there. I have a key point and a key takeaway. So the key point is, even if a privacy law doesn't apply to employees or individuals connected to the organization in that capacity, those laws may still apply to the individuals outside that capacity. I mentioned that, but I want to reiterate it. So if you visit a website as an individual, not an employee, you sign up for a newsletter because you just want to get it, or blogs and things like that, or if you make purchases in your personal capacity. And then finally, this is something that you absolutely must remember, that even if a specific law doesn't require you to have a privacy policy or notice or to comply with all of these requirements, it's nevertheless a good practice to have it. It builds confidence with employees. It can take away some ambiguities as to, expectations. There are security cameras in the lunchroom, not in the bathroom, things like that. So, so it helps them to really address any limitations also on their expectations of privacy. And with that, we are finished. I will turn to the question Q&A, and if I see that I have at least 3. And like I said, if you have any questions that are more specific, happy to deal with those outside of the webinar. So thank you very much. I hope it was helpful, and let me see what we have for questions. We have a director who refuses to give his home address to our company for payroll records. He's just provided us with a PO box, just looking for guidance if we're okay to just let that be. I don't know of any law but again, I'm not an employment lawyer per se, I'm a privacy lawyer, but I don't know of any privacy law that requires someone to give you their home address. But I think if you have a company requirement to have that and you need it for some reason, for tax or other purposes, you may be able to obtain that. Or in the privacy context, sometimes, like with cookies, for example, if people refuse to agree to certain cookies, then they just don't get the service. So I can't really answer that more specifically. That would be something, I'd have to talk to one of our employment folks and look into further. The next question is there an Excel sheet or easy to view privacy laws and record keeping requirements? There are resources online. There's an organization that I belong to called the IAPP, the International Association of Privacy Professionals. They have a tracker that tells you what states have enacted laws or what the status of legislation is that's pending. I don't know of any single resource that would help you with individual record keeping and things like that. And there's also and I forget what it is, but if you Google it and look, there are websites that will. I think it's DLA Piper. They have I believe it's a resource there. It may be old now. I think it might go back to 2019. So to the point that things change quickly, that's true. But at least as of that point in time, it was a summary of the privacy laws in virtually all of the countries. I can't think of anything else specifically that's up to date. websites that are keeping current with those laws. And the last question I have is, who are the authorities that you
Hi, Doug. I think we lost connection with you. Okay, well, thank you everybody for attending. My apologies for the abrupt ending. If there are questions that Doug did not answer, we will be sure to connect with you and provide appropriate response. In the meantime, please look for an email from us that will include the PowerPoint presentation as well as a recording of the program. We expect to send that later today, and please note on the last slide, there is information about SHRM credits. Thank you and have a great day.